We'll first start with kind of introducing ourselves. So I've just met some of you, but my name's Mital. I'm an education community care solicitor at Just for Kids Law, and I head that department and the housing law department at Just for Kids Law too. I've been here for a really long time. I started in 2012, so it's over nearly 10 years. And have been here throughout and doing the same work that I'm doing now. My main work is, besides running the department, is assisting children and young people in various matters. That includes obtaining support from social services, acting in school exclusion cases, obtaining support for children with special educational needs. That's kind of the core of the work that my team does. We also work quite closely as an organisation with the other departments, including our policy team, who I think you all know or may know that do kind of various work on 16 and 17-year-olds facing homelessness.
So hi, I'm Sophie. I'm one of two advocacy managers at Just for Kids Law. Like Mital, I'm a long-standing employee of Just for Kids Law, but I've done various different roles since I've been here. So I initially joined the organisation in 2015 as a young parent advocate. I've also worked as a development manager for the organisation before rejoining the advocacy team last year in my current capacity as an advocacy manager. So our advocacy team help children and young people between the ages of 10 and 25 with understanding their rights and entitlements and getting their wishes and feelings heard by the professionals working with them. Our advocacy support is always client-led, and we support children and young people at the point of need with issues ranging from housing and homelessness, social services, immigration and residency status, criminal justice, education, finance, family, including for young parents, and healthcare. The advocacy team also work closely with the policy team at Just for Kids Law by helping to identify recurring issues that our clients experience.
So a bit more about the organisation, I know who we are. So Just for Kids Law was founded by two youth justice lawyers, Shawneen Lamb and Ika Stevenson, in 2006. Shawneen and Ika both work in youth justice, and they're both youth justice lawyers, and they recognise that children and young people they worked with often needed more than legal representation with their criminal matters. They recognised that they also needed support, like advocacy support, to address the other issues that were in their life that potentially also led them to the criminal justice system. So, for example, they recognise that some young people may have not been in education, or they may not have had the support in the education system that they needed, or they have special educational needs. Young people with mental health issues were presenting themselves in the youth justice system, which I think we all know is a common issue. Children that are in the care system who weren't receiving adequate support, and children who are facing housing problems.
So since our first youth advocate was appointed in 2008 to work alongside our lawyers, we've expanded into an organisation offering a unique holistic service that combines direct advocacy with youth opportunity services, so that includes supporting young people into employment, work and training, and legal representation. While we have also used strategic litigation to change the law on issues as diverse as holding of children in police cells, the law of joint enterprise and access to student finance. We have spread our impact through the advice and training delivered by our Youth Justice Legal Centre and widened the scope of our work from casework and campaigning to holding government to account on their child rights obligations through the merger with the Children's Rights Alliance for England in 2015.
So now we're going to kind of go on to talk about what our approach is to supporting homeless 16 and 17-year-olds. We regularly receive referrals for homeless 16 and 17-year-olds, which is why we are strategically trying to address this issue or work on it. Our approach has encompassed many factors, including ensuring that the young people are safeguarded, helping the young person understand their rights and entitlements, providing support to navigate difficult situations that they're in, whether that be through advocacy support or legal support, to help them to communicate their wishes and feelings to the professionals that they're working with, and ensuring that their voice is heard, helping them to advocate for themselves, understanding the possible difficulties and the trauma the young people that we're working with may face, and supporting them from a perspective where we understand the potential trauma that they face. Also understanding the wider safeguarding issues that young people are suffering. So this is kind of talking about more contextual safeguarding issues, like the issues that they may be suffering outside of their family home. Some of these cases, in theory, can be picked up by either of our advocacy, by both our advocacy team or legal team, or either. It depends on where that young person is in that situation. What we have found is that it works really well if our advocacy team and the legal team, or a lawyer and an advocate, are working with the young person together, because then they're getting support in all aspects of their life, hopefully, if that's what the advocacy service that they're working with provides. What we found in our organisation is that over the years, where our advocates can in the first instance support homeless children and young people by advocating for their rights and entitlements, and supporting them to advocate for their own rights and entitlements too. This often results in the young person being accommodated and their needs being assessed and then being supported. But obviously there are situations where, despite all the efforts made by our advocacy team, that homeless young 16 and 17-year-old is denied their rights to accommodation by the local authority. And in those cases, and we'll kind of discuss this a little bit later in the case studies that we'll talk you through, where advocates support the young person in instructing a community care solicitor or a housing solicitor, depending on their situation and what support they want. Our advocacy team also continue to work with young people after they've been accommodated with the other support needs that they may have.
So we're now going to take you through some case studies which will hopefully contextualise many of the issues that have been covered in the guidance. What you'll notice is that some of the myths that are detailed at the end of the guidance, the Homelessness guidance, are featured in some of these case studies. And the case studies are amalgamations of different cases that we've come across in our practice. So we're just going to start with Melanie. So 17-year-old Melanie became homeless when her mother passed away and her relationship with her stepfather broke down irrevocably. She approached Children's Services on multiple occasions and was told that there was no accommodation available for her because she was nearly 18 years old. During this period, she was forced to spend the night in places that were open for 24 hours, such as McDonald's restaurants, casinos, and hotel receptions. Eventually, she was placed in supported accommodation. She thinks this was under Section 17 of the Children's Act. However, she was asked to leave after only 2 weeks because she let a friend of hers, a child, spend the night at the accommodation, which was a breach of the rules. She then became homeless and sofa surfed again before being housed in a hostel and eventually in another unregulated placement where she stayed for 6 months. The only form of support she received throughout this period was from the form of food vouchers from Children's Services under Section 17 of the Children's Act. And as a result of her financial difficulties, she became involved in criminal activities. So what happened next for Melanie after she received the support from our advocacy team at Just for Kids Law, she was supported with requesting that she's looked after under Section 20 of the Children's Act, and that she then became accommodated in suitable placement. The advocate highlighted the statutory guidance which states that where a 16 or 17-year-old who appears to be homeless or at risk of homelessness seeks help from or is referred to Children's Services, Children's Services must carry out an assessment, which hadn't been the case when Melanie had originally approached statutory services. And the guidance states that this also includes 17-year-olds who are nearly 18 years old, and that's in paragraph 3.1 of the relevant guidance. The local authority eventually accepted this request, and Melanie was then placed in supported accommodation under Section 20 of the Children's Act and was provided with the support that she was entitled to. She remained in this accommodation until her local authority made a direct offer of social housing and assisted her to transition into adulthood. However, after Melanie turned 21, She was told that her case was going to be closed despite still wanting and needing ongoing support. She was at risk of eviction from her accommodation, and her advocate at that point informed her of her rights and entitlements as a care leaver to receive ongoing advice and support from a personal advisor. So the myth here with Melanie's case was that she was not entitled to Section 20 support because she was nearly 18. This is something that we do come across quite a lot in our practice. Young people who are approaching their 18th birthday and are told that they aren't entitled to this support because they are so close to their 18th birthday. But actually the law states, the statutory guidance states that any child under the age of 18, even if this is by one day, is entitled to the Section 20 support. Another issue with Melanie's case is that she didn't seem to understand her rights and entitlements. And this is evident from the fact that she'd accepted this accommodation and she thinks that this was under Section 17 of the Children's Act. This sort of it would illuminate for any advocate working with her that she wasn't entirely clear what the different options were that were open to her. And we do encounter this a lot, where 16 and 17-year-olds have been accommodated, often under Section 17 of the Children's Act, believing that this was the only option open to them. However, in Melanie's case, had it been explained to her that there was another option, an option for her to be accommodated under Section 20 of the Children's Act and to receive the additional support that comes with that, it's likely that she would have requested to be accommodated under Section 20 of the Children's Act from the outset. And had this happened, it's likely that Melanie wouldn't have had to experience all of the trauma of being homeless again, being kicked out of her supported accommodation, and ending up getting involved in crime in order to financially support herself, and sofa surfing. All of that would have been avoided had she been able to request the support that she so clearly needed, and had her needs adequately been assessed in the first instance.
I think the one thing that we, I know this isn't relevant to 16 and 17-year-olds, but is that young people that have been in care will often have ongoing needs that go beyond their care needs. So for example, that last bullet point about what happened next to Melanie, where she turned 21 and they tried to close her case. We won't go into depth about this, but obviously as a care leaver, she was entitled to support until she was 25, and after 21 she's entitled to support if she wants it. It's her choice, and the local authority should, kind of making this very brief, but should, if she asks for, provide her with a personal advisor, and also provide her with ongoing support and advice, and assess her needs and provide her with a pathway plan if they think that is relevant. So it's really important to kind of recognise that it goes beyond them being 16 and 17 years old, or the support they would be entitled to when they're 16 and 17.
So our advocacy service, we do continue to support children and young people beyond their 18th birthday, particularly when they're in situations such as Melanie's, and where their rights and entitlements change quite dramatically once they turn 18. So I think that's Melanie's case.
So we'll move on to Jason's case. So Jason was known to Children's Services since he was really young, due to his mental health difficulties and due to the kind of difficulties he'd had, the relationship between him and his parents. When he turned 17, he was asked to leave the family home forever. I said forever because he'd experienced being kicked out previously, and this is often something we see where children or young people are asked to leave the family home repeatedly. And then it comes to an ultimate point where they're asked never to come back, or it doesn't come to that point, but both are problematic. He approached the local authority's housing department. He wasn't aware of the difference between children's services and housing services. This, again, often I get told by young people, oh, I went to that housing place on X road, because that's what they know of, that's what they've heard maybe their parents go to or their friends. Well, that housing department advised him to go to Children's Services because he was a child. The social worker told Jason that they were going to do an assessment of his needs, which they did do, but they didn't really ask him any questions. They didn't really assess his needs. The only thing they did was ask him why he doesn't really stay out of trouble, so that his parents don't get annoyed with him and kick him out all the time. At the end of the assessment, the social worker said that Jason's only need was accommodation. Oh, sorry. So he's not entitled to Section 20 accommodation, and he could go back home to live with his parents and approach the housing department for accommodation. And again, this is something we see quite often, that social services are trying to ask young people to go back to their family home where they've been asked to leave, or whatever situation has happened there. Jason went back to the housing department because he was told that he could do that, and he was accommodated under the Housing Act. He was accommodated in unregulated placement and was provided with a £25 food voucher. Based on the actual case study, the real one, I think that food voucher was provided under Section 17 of the Children's Act as a child in need. So social services did provide him with some support, but it was literally a £25 food voucher. Because of his situation, because of his financial difficulties, he had no choice but to start working, despite being told and advised that this would impact his benefits, which he then struggled to manage, resulting in him accruing rent arrears and becoming at risk of being evicted. At this point is when he actually approached us. As you'll know, So what happened next was that our advocacy team worked with Jason. They advocated and supported him to avoid being evicted, and they also tried to challenge the rent arrears he'd accrued, because they weren't accrued due to his own fault. The legal team supported Jason to argue that the local authority failed to assess his needs under the Children's Act and provide him with accommodation under Section 20. We also argued that the local authority acted unlawfully and that it should now treat him as if he was a former relevant child and provide him with leaving care services to assist him transitioning to adulthood. This became, this case study is based on a real story, as Sophie has said, but obviously it's changed quite drastically. But for the young person that we did support in this situation, he was actually 18 when he approached us. And so I'll talk a little bit about that later, and how we can support young people in a retrospective sense. The challenge was successful, and he was provided with leaving care support and was able to clear his rent arrears. Now, there are so many issues with this scenario. The myth that we kind of connect to the guidance that we've created is that the only support Jason needed was to be accommodated. So he wasn't entitled to Section 20 support. That's kind of the theory, that because there are no other support needs, that there's no reason to make him a looked after child. Also the sense that the young person, or Jason in this scenario, is resourceful, autonomous, and is able to live independently. So again, doesn't need to be looked after by social services. Like I said, we often see this, and where local authorities go to some length to try to ask young people to kind of return home to their family. This might involve simply telling young people to return home as they aren't able to support them through children's services. They might do this by contacting the family to ask whether the young person can return home, or telling the young person to go home, like they did in Jason's scenario. What's important to remember is that in order to receive Section 20 support, the young person doesn't need to have these additional needs that the local authority is stating he does need. In our experience, it's likely that the young person will have additional needs beyond accommodation anyway. Obviously, that might be not the case in every scenario. If the young person's situation meets the test of Section 20 support, the local authority have an automatic duty to provide the support. They can't really say no to that support. The test for Section 20 accommodation is set out in GV Southwark, and I think we talk about that in the guidance, but it's really simple. It's that Jason is a child, he's a child in need, which is child in need under Section 17 of the Children's Act. That he appears to the local authority to require accommodation, and that's because there's no one who has either parental responsibility for him, or he's been lost or abandoned, or the person who has been caring for him is being prevented from providing him with suitable accommodation or care. The local authority should, in this scenario, in considering Section 20 or looked after child status, also look at what Jason's wishes and feelings are in relation to his situation and his accommodation, and they should consider those wishes and feelings. There are other issues in this scenario as well. Sorry, I've gone into a bit of depth in this case study. it's clear that no thorough assessment of Jason's needs was done in this scenario. So, for example, they hadn't assessed if he had any financial needs. I know they gave him a voucher, but that's not sufficient enough for him to buy all of his food and support himself with kind of any other necessities. They hadn't looked at what his educational needs might be or any other aspect of his life. Like Melanie's case, Jason's been fully aware of his rights. Had he been fully aware of his rights and entitlements in relation to Section 20 versus housing versus Section 17 support, and aware of the fact that he could have had financial support, etc., then he probably would have advocated for himself to be accommodated under Section 20. And one of the other myths in this scenario is that Jason's able to live independently without support, as he's shown some signs of being independent. We often hear local authorities make assumptions about a young person's independence, stating that they're independent because they're resourceful, because they're confident, or they show some confidence because they've been able to advocate for themselves, or they've been able to manage, they've shown some evidence of managing some stuff in their life, like carrying on with their education while they're, you know, in an unstable situation, being able to cook or clean. And this is despite these being really kind of just small aspects of their life. There's an assumption that makes them independent enough to live by themselves and not have any support from a parent or a corporate parent. There's also the assumption that Jason was to blame for being kicked out. That is problematic, obviously, because unless they assess the needs, they can't assess that, and also it's making an assumption, but also not listening to Jason in regards to his needs. In our experience, it's really important for professionals working with young people to take the time to listen to them. Young people may not want to talk about something or talk about the issues that they're facing or some particular incident, as they might be worried about getting someone else into trouble, like their parents. There's also the assumption that Jason can return home and be safe, again, without assessing the risk to Jason. That is not a good assessment in my view. And there was no exploration as to what other support needs he would have. And again, a good assessment would have looked into that. And also, as I said before, there was no kind of context, or no looking at the wider context of the issues Jason is facing.
I just wanted to come in actually on the point about our advocates, when they support children and young people in Jason's situation to get a thorough assessment, it's often not just about getting the assessment, but it's about supporting them to really get their wishes and feelings across. What we often experience, I think this is both with children and young people who have had experience of working or their families being known to children's services, and those who have no experience of children's services, it can be incredibly daunting to speak to social services. And in particular, we do encounter some young people who are really fearful of speaking about what's going on for them at home, or going into any depth about the full extent of what they're experiencing at home and why that's driven them to sort of either run away, leave home, or to have been kicked out. And then they're not keen on expressing this to children's services because they're fearful of getting, as Mital mentioned before, their parents or family members into trouble. And this is why it's so important for the advocates, our advocates working with the children and young people, to really help them to understand their rights and entitlements and what they are able to share, and to support them to get their wishes and feelings across in a way that feels most comfortable to them, whilst ensuring that the professionals around them are really up to speed with any safeguarding needs that there may be. So now moving on to the next case studies. This was a slightly shorter one than Jason, and this is Ricardo. So Ricardo, again, was 17 years old when he was kicked out from the family home in Essex by his parents. So Ricardo did not have any family or friends in the area, and therefore travelled to Islington to stay, where he was sofa surfing with a friend in the friend's university accommodation. He stayed there for several weeks before being told that he approaching children's services for support. When Ricardo went to children's services in Islington, he was told that he should approach Essex County Council, as he was not from Islington. The social worker at Islington did not do an assessment of Ricardo's needs or provide him with any support, even though he had no money to buy food or essentials, and he could be kicked out by his friend at any point, as his friend was not allowed to have him there. The social worker did not did offer to pay for the train ticket back to Essex, which was kind of them. So in terms of what happened next after Ricardo received some advocacy support from us, Ricardo's advocate supported him to contact Children's Services again in Islington to request that an assessment of his needs is conducted and that he is provided with accommodation in the interim. The advocate also supported him to contact his social worker at Essex to ask them to do the same. Islington Children's Services said that he was not their problem and that he should go to Essex Children's Services. Around this time, Ricardo's friend received a warning about Ricardo staying with him, and Ricardo had to leave the accommodation in a week. Ricardo's advocate exhausted all attempts to work with Children's Services at both local authorities, therefore supported Ricardo to access legal advice. Ricardo instructed a community care lawyer to challenge both local authorities' failure to assess his needs and to support him, and the solicitor sent pre-action correspondence to both local authorities, and Ricardo was eventually accommodated under Section 20 by Islington. So there's only really one myth here, and that is really that in Ricardo's case, and that is the dispute about where it is that Ricardo ought to, which local authority has a responsibility to accommodate Ricardo under Section 20. So although obviously he approached Islington, he had been told that he needed to approach Essex County Council. The statutory guidance states that homeless 16 and 17-year-olds should be accommodated under Section 20 of the Children Act by the borough that they present as homeless to. So in Ricardo's case, that would have been Islington. So like in terms of the other issues that have arisen in terms of Ricardo's case, it's very similar to Melanie and Jason's cases before. Again, Islington failed to carry out a thorough assessment of Ricardo's needs, and this is something that his advocate later supported him with requesting. Ricardo's case, I think, is a good illustration of how, in some cases, despite the young person understanding their rights and entitlements and being supported, in this case, by an advocate, to advocate for them to be accommodated under Section 20, sometimes their rights to accommodation under Section 20, to be accommodated under Section 20, sorry, are still denied, and they will need to access legal advice from a community care lawyer to take things further. I'd like to say at this point, actually, that in many instances, it just requires the support of an advocate to really fully communicate, to support the young person to clearly communicate to Children's Services that they understand their rights and entitlements and that they have made an informed decision about wanting to be accommodated under Section 20 of the Children's Act, if that's obviously what the young person wants. But however, sadly, we do come across cases like Ricardo's where, despite the attempts and efforts of the young person to advocate for what it is that they want and the advocate supporting them in doing so, there are these instances where their rights to access Section 20 support are still denied and that they will need the support of a lawyer.
And I'm going to kind of chime in as well. Just to kind of, one thing I'll say as a kind of caveat, just because I'm a lawyer, that obviously in this scenario, Ricardo gets support from Islington or the borough that he had approached originally. That's not always the case. It's not as simple and straightforward as it is a bit complex. But what is important to know is that social services or local authorities shouldn't be pushing a child pillar to post. I think that's the language that was used in the old guidance. They shouldn't basically be saying, no, go there, we're not going to help you. What they should be doing is providing that immediate support to the child and then figuring out whose responsibility that child is. And I think that's really important to know and hopefully helpful. We'll move on to Rachel, which is our last case study, because we've been quite in depth with the other ones, so I won't go into too much depth. But Rachel was 16, nearly 17 years old when she became homeless and approached Children's Services. Social Services did an assessment of her needs and decided she did need accommodation. The social worker told Rachel that she was really independent and that she had a few choices. She could be accommodated by Children's Services, but then she'd have to stay in foster care or a children's home, more likely foster care, where she would have be living with somebody, and she would have a curfew and rules to follow, potentially even other children living there who are also being fostered. And she'd also be visited by social services a lot because they'd be checking up on her. or the alternative was that she was independent and able to look after herself, and she could get accommodation from the housing department. She wouldn't have to have a social worker coming round a lot and checking in on her all the time, and basically ask her what she'd like to do. Again, this is a scenario we see very often, where a young person is presented with kind of two different pictures, maybe not deliberately, but it gives the perception that one might be better for them than the other. In this case, what happened is that Rachel's youth advocate went through Rachel's options in more detail and explored and explained to Rachel the support she could receive by children's services as a looked after child, and explained what support she could receive if she did go down the housing route. The support she would receive as a looked after child also included the support she would receive after she turns 18 as a care leaver, and explained that concept to her. In terms of housing, they explained that she would be priority need for support, which would hopefully entitle her to accommodation under housing. However, the advocate explained that she wouldn't get any support under housing for other issues or other aspects of her life, like finances, or if Rachel was interested in continuing with her education, and support around that, supporting her even transitioning into adulthood or finding more permanent accommodation. Rachel considered all of this information. I'm sure she went back and forth with her advocate and asked questions, and then eventually decided that she wanted to be accommodated under Section 20. Now, the myths here are that she could be accommodated, that the only accommodation available to her as a looked after child would be a foster care placement or a children's home, which is utterly untrue. There are various types of accommodation available to young people, and that they are actually listed and set out in the statutory guidance. There's also the myth that she is independent and therefore doesn't really need that, or the kind of hint that she doesn't really need somebody, in her life constantly, like a social worker. These situations are really, the Rachel situation is really similar to the others that we've talked about, in terms especially of the kind of being independent. And we often find, not in every case, but that 16 and 17-year-olds, there are presumptions made about them being more independent if they don't have any specific, like identifiable needs. There is also the scenario, and I wanted to touch on this, and I kind of mentioned it earlier, that we get lots of cases for 16 and 17-year-olds who are trying to access support because they're homeless. We also get lots of cases of of adults or young people over 18, generally between 18 and 21, who had been in this situation when they were 16 and 17 but weren't provided with the right information or the right support, so the local authority failed to support them, and that we have supported those young people to challenge those decisions, and we call them retrospective cases. I think they're fairly universally known as retrospective cases, and basically that involves the lawyer challenging the local authority's failure to support a child when they were 16 or 17 years old, and get them support as a care leaver now. Again, this is quite complex, but what I think would be really helpful is that if you do come across children and young people in that situation, or young people in that situation, young adults in that situation, and you think that there may have been a failing, even if that young person had, when they were 16, 17, refused accommodation under Section 20, I think it's definitely worth exploring, and for them to get advice from a community care solicitor as to whether they could challenge that decision and now get some support as a care leaver. I
think a point that I just wanted to raise about Rachel's case actually is about actually how, as advocates, when working with homeless 16 and 17-year-olds, it's so important for us to explain the distinction between the support that Section 17 of the Children's Act versus Section 20 of the Children's Act offers these young people after they turn 18, because it actually can have quite a big influence over what it is that the young person decides that they feel is best suited to their needs. And often it is that ongoing support that they may receive once they've turned 18, that may help with things like, you know, if, for example, they run into rent arrears and they get evicted from wherever it is that they may be living post 18. This is often what I've found in many of the young people that we've, 16, 17-year-olds that we've worked with, tends to sway it for them, because otherwise sometimes the option can feel indistinguishable if they don't feel that they have any additional needs in addition to the need to be accommodated at that moment, whilst they're 16 and 17. So yeah, it can be quite important to be able to go through the distinction between the different support that is offered post 18.
And the last point I think that just to follow on from what Sophie's saying, that I'd like to make is that there is actually I forgot my point. I don't have a last point. Sorry. So we wanted to leave a big chunk of time for Q&A, which I hope we've done. I can't actually see a clock, but I think that we have. So please feel free to ask us questions. Obviously, we can't answer any, give specific advice about a particular case, but it'd be really good to hear kind of what you're coming across and what other situations or any questions you might have for us.